first question you kind of throw out is, who can be an ACO? And the answer is, if you go online, anybody's an ACO. They have all kinds of ACOs. But when people are really talking about these ACOs, they start with the Medicare Shared Savings Program ACOs. It's probably the core ACO concept that started. And then we move into our state. The governor signed this bill in 2012. There was a nice picture on the first slide, creating a process for ACOs to be certified in this state. And just to show you the reality of it, part of that legislation was that all of the government programs in this state are going to move to alternative payment methodologies over the next 3 years. So this is not something out there. When you think of the Insurance Commission and all the Medicaid and everything else, it's moving this direction. And if you think about what it's going to be in our state, the regs aren't out yet, but we know it's going to be a separate legal entity from its participants. We know it's going to have an administrative officer, a medical officer, and a patient or a consumer representative who's going to be on the board. We know it's going to use a so-called alternative payment methodology, which means something other than fee-for-service. We haven't seen the regs yet. We know it's going to have to coordinate payments among providers. We know it's going to be interoperable in terms of the IT systems in it in order to qualify. We know it's going to require, and this is going to be very interesting, it's going to require transparency in pricing so that patients will be able to look at the actual prices that are going to be paid by the provider, charged by the providers in the system. That's going to be revolutionary in terms of what that actually is. And it's supposed to engage patients in shared decision-making. And exactly how that's going to work, we'll have to see. There's a lot of talk about, extending CAHPS-type surveys, which are in the hospitals now, on into physician practices as part of a mandate. When you think about, next slide, some of the issues that are involved, we've kind of talked about them. Those of you that were practicing in the 90s, remember we heard all this before. Remember the first time around, it was IPAs, capitation, risk-based, bend the cost curve, et cetera. Into one of the comments that was just made, you recall in the 90s, it got a lot of momentum for the first couple of years, and then there was a revolt. And the revolt was driven by, I think, practitioners, and I think it was also driven by the public, who found that their ability to get the medical care they wanted was too restricted. Whether that's going to happen again or not, we don't know. But that's what happened when we tried this in the 90s. Now here, one of the things that happened in the 90s was that some of the groups and some of the organizations that took risk blew up. They couldn't handle it. They didn't know how to deal with risk, and they went bankrupt. Now this time, the state has learned there'll be more restrictive requirements, but one of the issues is still, are the organizations that are going to be ACOs going to be financially solvent enough to take risk? As I said a few minutes ago, if you're going to take risk, are you financially solvent enough to take risks is going to be a question. The IT resources, you heard me say they're going to be interoperable. What kind of investment is that going to mean? What kind of skills is that going to take? Term and termination provision, those of you that are in managed care organizations now, I think it's going to feel a lot like that, for better or worse. What that means, in the extreme, so you're going to see contracts with some that are kind of take it or leave it, and with others, if you're organized, I think there's an opportunity to have some input. Exclusivity will be a question. I think, as you heard Chris say, on the Medicare side, there's on the PCP side, it's already going to be exclusive. That means you're going to have to make some potentially hard choices. The law in our state favors tiered networks, which isn't exclusivity, but I would call it incentivization. And so again, when you choose networks, it's going to have meaning. Does the agreement violate the law or existing contractual obligations? Some people have most favored nations clauses where they say, I'm going to give you the best price. How's that going to play when the next guy comes along? What are the compensation terms? Simply how am I going to get paid? When am I going to get paid? If I'm in a risk-based environment, do I understand what the formulas are? Can I audit the formulas? And can I truly understand how they work? And make sure that if I don't understand, somebody can audit it and see that they made the right decisions. How am I going to submit claims, and how am I going to get paid? Am I going to use the standard forms, or are we going to involve in some different form? Am I going to be required to do this all electronically? And if so, do I have the system to do it, or is somebody going to give me the money to upgrade my system to do it for them? I thought the comment that was made about knee-high and, why don't we agree on just 3 formats, and that would have been a lot easier than making it easy for everybody, was an apt comment. But we are where we are. And then what covered lives, if I take risk, will I actually be responsible for? How do I verify eligibility on a real-time basis? Because I'm not calling the carrier now, I'm calling this ACO to see if it's one of their members. The question was asked, who owns the data, or who owns the medical record? Of course, my medical records are my medical records. My risk adjustment data, which I feed into the system, is the risk adjustment data of the system. If I need it back, or I want to get it back, I'm going to have to build into my contract the right to get back the data that is massaged about me that's in the system. It's an interesting provision. It's not in most of the formatted managed care contracts today, but over time, because performance will become an important issue, that's data that you ought to be able to, A, get back, and B, use. Right? It's one thing to get it back and have it be bound as proprietary. It's another to say, if I terminate the contract, I'm entitled to at least have the data about my own performance. And this is one area where I would say, don't ask, don't get. So this is, to the extent this is important, it is important. Next slide. And the last thing I would say about this is that, these things don't happen in a vacuum just because you're in an MCO. If Chris and Jim and I want to get together and talk about prices we're going to give an MCO, that's fine. The trouble is if I use those to negotiate outside the ACO with Blue Cross, that feels a lot like we've agreed to the price, so you have to be sensitive to price fixing, right? So we don't happen in a vacuum. Or if I go to a hospital and I say, well, I'll tell you what, I'll join your ACO for, we're going to have workers' comp, I'll join your Medicare ACO as long as you guarantee me that I'll continue to be able to provide the following services on a commercial basis. That feels a lot like swapping. Swapping is a kickback, and somebody will be watching this kind of stuff. You can't swap participation in Medicare for something else, or something else for the ability to participate in Medicare. They kind of stand on their own unless they've been packaged together by the payer. So you do have to have some sensitivity to this and the spillover effects, and it's always best to have all of your relationships be, you've probably heard this in the Stark context before, but it's just good business, in writing for at least a year, and something that feels like fair market value. If you do that, you're probably going to be okay no matter what you do.